Good morning, my name is Michael Chapnick,
I'm David Kupperman.
and today we're proud to present this webinar on residential eviction issues and strategies. Now, some of the most important things to remember about a residential eviction are accuracy is crucial. If the 3-day notice or the 7-day notice, if appropriate, has the wrong information, it's going to be invalid.
Timing is equally important. If you file the eviction suit before the notice period expires, your eviction will be dismissed. And remember that in counting the 3 days or the 7 days for the notice, you do not include weekends or legal holidays.
Speed. Remember that the main goal of a residential eviction is to get possession of the unit back. Follow the steps in order as fast as the law allows, and everything will be fine.
The foundation for an eviction, of course, is the lease agreement. And a couple of points that we wanted to make was, first, the tenancy, the duration of the tenancy. Under Florida law, if the lease specifies what the tenancy is, that's the tenancy that controls. But if it does not specify the tenancy, the duration is determined by the frequency with which rent is paid. If rent is paid weekly, it's a week-to-week tenancy. If rent is paid monthly, it's a month-to-month tenancy, and so on. The other point was that the lease should not contain any language that seemed to be overreaching or excessive. And what I mean by that is a provision in the lease that seems to waive the rights or defenses of the tenant, or otherwise limits the liability of the landlord, contrary to what the statutes provide. If you have an overreaching provision, the lease, the entire lease, could be declared void, not just the provision that's questionable.
Now, tenant breaches. There are several that we're going to talk about, the first of which is a monetary breach. If a tenant fails to pay rent when it's due and that default continues for 3 days, not including Saturdays, Sundays, or legal holidays, after you deliver written demand that you want payment or possession of the property back, the landlord is entitled to terminate the lease agreement. Remember again, legal holidays for purposes of an eviction are only court-observed holidays.
The other type of breach is a non-monetary breach, something that involves an issue other than the payment of rent. And depending on what that breach is, you may be required to give the tenant an opportunity to cure the breach, or you may not be required to give an opportunity to cure. The most extreme instances are one where the tenant doesn't get an opportunity to cure. That would be where the tenant commits the same violation within a 12-month period after having previously been warned that their lease would be terminated and a subsequent violation would result in termination, or an instance where the tenant has caused damage or destruction to the property. It's creating a safety issue. There's criminal activity, drug dealing, something of that nature, to the point where the tenant should not be given that opportunity to cure. Notice needs to be given by the landlord saying that you have, because of the violation, you're not being given an opportunity to cure, your lease is terminated, you have 7 days to vacate the premises, otherwise an eviction will be filed. On the other hand, there are some instances where the tenant is required to be given an opportunity to cure, and that is for things such as parking violations or unauthorized guests, pets. You still give a 7-day notice saying that you have 7 days to cure the violation or your lease will be terminated. If they cure the violation, that's it. Fine, no problem. If they don't cure the violation within the 7 days, the lease is deemed terminated and you go ahead and file the eviction action. It's important to document what the breach is. If you have witness statements or photographs or any evidence in your file, because if it becomes an issue in court, you're going to need to show proof what the violation was, what notice was given, and what you expected the tenant to do. If you have it all laid out, you won't have any problem.
Now, Florida statutes provides us with language that we can use to provide notice to the tenant of monetary breaches, breaches where there's an opportunity to cure, and breaches where there isn't an opportunity to cure. We recommend that the statutory language be followed exactly. While you can include additional language, don't omit any language. The language has been tested, it's been proven, it's accepted by the courts, and if you vary from the language that's included in the statute, the notice may be deemed invalid. Remember also, when you deliver the notice, it has to be either by mail-in, hand delivery, or you can post it on the premises if the tenant is not in occupancy.
Again, you want to document your method of delivery. If you post it on the door, take a photograph with a date and time stamp. If you send it by certified mail, make sure you have the receipt and the tracking information. And the notice, at least in Florida, is jurisdictional. There's case law that says if there's a problem with the notice, your eviction gets dismissed and you have to start over. So our only caution is if you're going to be a little creative and add some language to the statutory form language, don't create a conflict within the notice, because there are cases that have held that where the tenant doesn't know exactly what to do because of conflicting language in the notice, the eviction gets dismissed.
Now, once you've already served your notice, you're going to file the lawsuit. Several ways that you can do that. You can file an action for possession only, or you can file an action for possession and money damages combined, or you can split them up and file two separate lawsuits, one for possession and one for money damages. On a possession-only suit, you're issuing a 5-day summons, and that's an expedited way to get back possession of your unit. If you do a combined lawsuit where you're seeking both possession and money damages, you're serving not only a 5-day summons, but also a 20-day summons on the money count. What we recommend is, in order to avoid confusion and to speed up the process, and remembering that the primary goal is always to get possession of the unit back, first you file your lawsuit for possession only. Later, if you decide that it's worth the landlord's time and effort to try and get a money judgment, you can file an action for money. It's going to be less confusing for all parties. It's going to result in a much faster possession of the premises. And honestly, if the tenant isn't paying you anyway, it's probably unlikely that you're going to recover money damages, and you want to carefully consider whether it's worth the time and expense of litigation to go and attempt to get the judgment.
A piece of paper that says that the tenant owes you something, but not be able to collect on it. Now, there are defenses that can be raised to an eviction, and we'll go through those. The first point that we want to make is that once you've started the eviction process, the tenant is required to put their rent into the court to maintain any of their defenses. If the tenant comes to you as the agent of the landlord and says, "Don't evict me, here's my rent," if you take any rent from the tenant, even if it's a partial payment, you're going to invalidate your eviction. So our recommendation is, in that instance, while you might be tempted to take the cash in hand, tell the tenant to deposit the money with the court, because you'll still be able to get the possession of the unit, and you'll get payment of the rent from the court at the conclusion of the case.
Now, anytime the tenant raises a defense other than non-payment, or other than payment rather, the tenant's required to put the money, rent money, into the court registry. If the tenant fails to do so, then the landlord is entitled to a judgment without hearing, just on a summary basis.
But if the tenant's going to raise another defense, they have to do something else. They have to give notice to the landlord. They have to say, "I'm not going to pay my rent to you, landlord, because you have not complied with your obligations under the lease." If the tenant does not give that notice, they have no right to withhold payment of the rent.
Now, remember that if the tenant fails to give notice, he's not entitled to raise any of those defenses.
They're waived.